All right, let's see. We've got Mr. Johnson, Mr. Hanks. Looks like we got the parties. All right, let's call the Peterson matter. It is case 20470195. Mr. Hanks is appearing on behalf of petitioner who's present. Mr. Johnson's appearing on behalf of respondent who's also present. This is the time set for temporary orders. I have reviewed the pleadings. We are starting a little bit early, so we don't have as much of a time crunch, but I will give both sides 10 minutes to make their initial arguments, and then at that point decide how much rebuttal I want. So let me get my paperwork out. All right, looks like Mr. Johnson, your client has the initial motion. I'll let you begin.
All right, so I would direct the court's attention to the respondent's verified declaration in reply to petitioner's opposition to her motion for temporary orders and in opposition to petitioner's counter motion, because that's what I'm taking this from. Starting with income, Derek claims, the petitioner claims, his average gross monthly income for the past 3 years has been an average of $20,664.71 per month, but that's without including certain money that's deducted for tax purposes. If you use the money that he is shown to earn from box 1 rather than box 5 of his W-2, you see that his average monthly income is not $20,664 per month, but $21,934.91. And of course, when we're dealing with numbers this big, one starts to wonder, how much of a difference it makes. But I'm simply pointing that out. So we have a difference between 21,934.91, so basically 21,935, and 20,665. If you use the numbers of 20,664.71, Derek's claim, and $175 per month for Camille, child support on a sole custody basis would be $2,732 per month on a sole custody basis, $2,236 per month on a 35.1, section 35.1 basis, and $1,380 per month on a joint equal custody basis with Derek at 182 overnights. If you were to use the number of 21,935 for Derek and 175 for Camille, the numbers would be $2,981 per month child support on a sole custody basis, $2,440 per month on a section 35.1 basis, and $1,506 per month on a joint equal custody basis with Derek at 182 overnights. Spousal support would be what we proposed to be the difference between the amount that Mr. Peterson states in his financial declaration. Would simply be about 7,000, if I remember correctly, 7,500 and, let me just find that. Have it over here. $7,357 per month. So he says that he has a surplus of $7,357 per month. So what we're asking for is that even though Mr. Peterson has overstated his expenses by at least $4,787 per month, he still claims to have a surplus of $7,357 per month. If you look at the respondent's financial declaration, which is inaccurate, but it's what we have in front of us. Inaccurate in the sense that it underreports her expenses, not overstates them. She would then say, just award to me in child support and alimony $7,357 per month. Mr. Peterson can afford it because that's his own claim to the surplusage that he says he has. But I will point out that he underreports his income because he claims to use box 5 instead of box 1 on his W-2 and overstates his expenses, specifically with regard to rent or mortgage, where he claims to have 2 mortgage payments or 2 payments for 2 households when in fact he only has 1, and that's for the marital home. He also claims retirement deposits of $1,583 per month on his financial declaration, which, as we know, would not necessarily be something he could withhold from his stated income and for his expenses. So he has, with his real estate maintenance of $500 per month that he claims for an expense he does not have, and $262 in utilities for an expense he does not currently have. That means his overstatement is $4,787, but you don't have to worry about that because he claims that even if you include those non-existent expenses in his expenses, his overage and surplusage is $7,357 per month. So to make it easy for everyone on a temporary basis, we ask for child support and alimony in the combined amount of $7,357 per month, regardless of what the child custody arrangement is. And then that way we have everything covered. Finally, there are a couple of questions Mr. Peterson has raised and that we're happy to address. And that is he would like to ensure that he can come to the marital home to remove his personal items. He also wants to remove tools. So we're objecting to that, but he's certainly entitled to any personal effects he has not previously removed from the house and any computers or other employment related equipment that he needs for him to do his job. There's been a request by Mr. Peterson for an order requiring each of the parties to pay and hold the other harmless for all debt in his or her own respective names. We have no problem with that. Are there any questions at this point then? I hope
Yeah, let me just clarify from you, Mr. Johnston, when you're saying that there's the ability to pay that 7,000, what's the number you're starting with? What's his gross number you're starting with?
Oh, I'm taking his financial declaration. He claims to have a monthly surplusage of $7,357.
Well, I know, but I want to do the math backwards. What gross income are you counting for him to start off with before I start subtracting things?
Well, I'm not using any. What I've done is I've said, regardless of whether we use his stated monthly number of income or Camille's claim
Then point me to where it says he has 7,000 extra.
in his financial declaration, when you
Yeah,
look
point me
at
to the
his,
direct, point me to where it says that.
I'll get there right now. So let's see. So I'm looking at the financial declaration that was filed on February 18th for the petitioner.
Okay.
And he points out that his total gross monthly income on page 3 is $23,209.54.
Okay, so 23,210. Okay.
Yes. And then
I don't
he
know why
says
everybody's
that,
using pennies. I don't want to see pennies. I want people to round up or down. We learned that in third grade. So
yes.
anyway,
So 23,210. He then
okay.
claims to have monthly tax deductions of $5,763, rounding up from 0.73.
Wouldn't that be a low amount though for that amount of income? Because that's not even 25%.
You're asking the wrong man. I was a
Okay.
humanities major. So what I'm doing is I'm going off of what
Okay,
is,
that's fair. Okay.
yeah, I mean, it's a good point to raise and one that I frankly did not think of, but I'm not interested in trying to force Mr. Peterson into a situation that it's untenable to him. So if it turns out that he did underreport his deductions, that should be taken into account. I don't know if the numbers he uses are incorrect or not. I'm only using the numbers that he has. So if you take on paragraph 6, you subtract that, he has a net after-tax monthly income of $17,446, rounding up from
Okay.
0.81. Then on his paragraph 7, he has his stated expenses, showing a total monthly expense of $10,852.28, and the difference is $7,357.
Well, if I take 17,447 and then subtract the 10,852, don't I get 6,595?
Yes.
Maybe
So it looks like I made a mistake there. My point would be simply give her the surplus off.
Okay.
Now, on a temporary basis, because clearly I have some questions of my own different from the courts, but now that those become additional questions that need to be answered.
Okay.
But on a temporary basis, and having entered the case less than a week ago, I just thought this seems to be a fair and equitable way of looking at it. Obviously, Mr. Peterson can't afford it, and that's not even if you take his word for what he said, but he's over-reported his expenses by almost $5,000 per month.
Let me ask another question. I know there was some discussion I think in both pleadings about the child that's autistic and has some issues. There are some issues about what he likes to eat or doesn't like to eat. I'm curious is, he's listed his current food and household supplies at about over 3,000. She's got it at over 1,200. Both of those for a regular situation seem high. Would it be your client's position that because of the child and the dietary needs or issues that he has, that they do have to spend different amounts? 1,200 is actually more reasonable than what I would
There's
normally find.
there's an element of having to get some specific foods that
Okay.
pertain to this particular child's special needs. But really, in speaking with my client, my understanding is it's because they are so busy and these kids are a handful that they do a lot of eating out.
Okay.
So it's not so much that they have specialized food to purchase.
Okay. All right. Anything else? I mean, I have read the pleadings. Anything else you want to highlight?
With regard to the
Johnson?
child custody and parent time, was there any question about phasing it in by starting at 33.35 for the month of March, then phasing it into 35.1 in the month of April, and then working our way up to the Ackerman schedule? That would actually have Mr. Peterson with the children in his custody more of the time in the summer. And the purpose behind this is to demonstrate that if Mr. Peterson is able to exercise 50-50 custody, this gives him an opportunity to prove that by phasing it in. And if it, for some reason at any phase-in point it becomes too much, either because Mr. Peterson concedes that or because Camille Peterson says he's doing a bad job and the children are suffering, that allows us to move at a fairly expeditious pace, but also doesn't put the children in danger of too much too soon, especially when you're dealing with an autistic child where, as no doubt you've seen, both parents have expressed concerns over routine being such a big matter for their oldest child. And making big changes in custody or anything else like that can have a deleterious effect on the child. So we're, as I'm sure the court knows, I'm the most vocal advocate of joint custody in the state. And so if Mr. Peterson can prove it can work, he deserves that opportunity. We're simply saying that because of Silas, the oldest child, we need to gradually do so. You'll notice I didn't say slowly, just gradually. That's our
All right.
position.
I don't have any other questions, and thank you, Mr. Johnson.
Thank you.
Mr. Hanks.
Yes, Your Honor. I appreciate the court being willing to receive more documents and probably is the norm, but there's a lot to say in this matter. Let me talk about the children issues first. The point I want to make, I think, that deserves a lot of emphasis is the fact that Mr. Peterson has been more than a typical father. In fact, that list that we supplied the court, Exhibit A, that was based on him going through his various pictures and other documents that he has. That's not a comprehensive list. Those are the events and things that he could remember from going through his materials. And it's a huge list. I counted up the hikes that he's taken, trips to the mountains he's taken with the boys. It totals 164 of those activities in approximately 4 years of time. Now I know that Ms. Peterson claims, well, he's the fun dad. He does all the fun stuff with them. Well, that's not true. I mean, a lot of these things are fun, but Your Honor, perhaps the most significant thing on that list is the fact that on a daily basis, virtually a daily basis, Derek is spending quality time with these children and has developed a close, loving bond with them. In addition to the activities, it shows that he puts them to bed, he feeds them, he bathes them, he brushes their teeth. This is not a situation where Mr. Peterson maybe spends a couple hours on the weekends, or that in the midst of playing golf with his buddies or going out with friends or playing computer games, he spends an hour or two with the kids. He is totally devoted to these boys. And that's the absolute truth, Your Honor. Mr. Peterson would testify that his life revolves around these children. When he would come home from work, he wouldn't go out with his buddies. He was there with the family. He was there helping and doing really wonderful, fun activities with these children. It's also important to note that when Mr. Peterson adopted Silas, Silas was, I think, just about 4 years of age. Mr. Peterson married Camille when Silas was 9 or 10 months of age. Derek is the only father that Silas has ever known. At the time of the adoption home study found that he was fully capable of providing for Silas, that he was ready for the adoption. Ms. Peterson agreed with that. I think it's also telling, Your Honor, that with respect to the adoption, we all know that if something happened to Ms. Peterson, there's not going to be a ramp up for him to get ready to have Silas full time. He's going to have him. Your Honor, with respect to the regular custody guidelines or the parent time schedules, there's not a required ramp up. When we have families divorcing, there's never a ramp up time. I probably shouldn't say ever. I mean, the court can do whatever is in the best interest, but
Right. I would object to saying there's no ramp up.
the point that there has to be some transition because otherwise it will stress this child. Well, look at it this way. Taking Mr. Peterson or minimizing his relationship with Silas, minimizing the time with this child, that will be the stress, that will be the greater anxiety here.
Well, Mr. Hanks, let me ask you a question.
Yeah.
So they separated what, November of last year?
November
Is that-
20th.
November 20th. Okay. And from that time, and I'm not looking at fault of who said
Right.
what or did what, because quite frankly, these are two adults. I don't necessarily care much about them. I care about these kids.
Right.
What has the overnight schedule been? I mean, how much time has the oldest child spent
Yeah.
overnight outside of his normal bed to like the now with dad overnight?
Right. Well, that's been one of the real points of contention because my client had desired it. She wouldn't allow it. The first overnight with Silas was, I believe, February 20th, late in February. And there had been agreements prior to that time. I think there was one weekend where it was agreed, at least my client understood there was an agreement for an overnight weekend. And then at the last minute, she reneged. And we had thought for a while, well, let's file a TRO. Your Honor, that has been a real problem here. We have a mother who is dictating every point, every time my client has the child, it has to be cleared by her and approved by her. It isn't right. These kids are used to having daily involvement with their father and quality time. And so, but yes, that was the first overnight, but it wasn't, certainly wasn't my client's desire to wait that long. And I would argue this, Your Honor, we ought to look at the marital status quo here with these children. The marital status quo is daily contact, not every other weekend, not the 30-3-35 parent time, not 35.1, regular substantial contact with these kids. That's the marital status quo. After separation, it was parent time as determined by Camille. And Mr. Peterson, to his credit, he was stuck in a difficult situation. How hard do I push on this? He didn't want to create more animosity that these kids could feel or experience. He was trying to make it to the time of temporary orders. And that's why you saw objections to prior counsel's motion for continuance. We need to have a ruling on this so that my client can see these children. That is just critical here. I think it's also telling that I think, well, let me indicate one other thing with respect to the overnights and this claim that somehow these kids will be traumatized. My client currently resides in his parents'
I will
home.
note that nobody has used the term trauma on the respondent side. It's an overused word.
That's noted. You can continue, Mr. Hanks.
My client currently resides with his parents. These children have spent substantial time with my client's parents over the years. They know them. They love them. They know all of my client's siblings and his family. They've spent substantial time there. They've spent the night in that home many times. And so the claim that there's going to be some anxiety with these children, there's no basis for that. And in fact, Your Honor, that weekend in February, the first weekend with overnights, there was no problem. That went smoothly, just as it always has. And so there is absolutely no basis for the argument that we have to transition somehow. My client is fully able to parent Silas and certainly Mac. He has been involved and parented this boy for 6 years, almost 7 years now. And quite frankly, the other Camille has not disputed his list of activities or time or events with these children. Those are the facts, Your Honor.
I object. We couldn't respond to the list of activities because we're not allowed to.
All right. All right. Anything else, Mr. Hanks, as it relates to that? Or do you want to move on to the financial?
Let me move on to the financial issues. First of all, Mr. Johnson totally ignores the factor for calculating alimony in terms of needs of his client. That's the basis for an alimony award in their financial deck.
Well, let me ask you a question about that, Mr. Hanks, because most of the time we deal with situations where there's not enough money to go around once they've separated.
Right.
But there is case law that talks about alimony to help the parties maintain the status or the condition of living, whatever you want to call it, style of living, while they were married. If there's enough income to do that, why would I not do that?
Well, because the alimony award is to be based on her needs. Again, she's the one who made that statement. That's what she claims her needs are. And so I think we base it on that. There's got to be some indication of what.
Then let me ask you this question, Mr. Hanks, because the new financial declaration has current amount and marital expenses.
Right.
So, and those are two different numbers.
Right.
One, she's saying currently she needs $5,800. Whether that's just to survive or whether that's what she's always had during the marriage, I don't know. But clearly what she's saying, what she had and needed during the marriage was more. So how do I differentiate that on a temporary basis?
Well, I think one way to look at it, I know on my client's financial declaration, and I think on hers as well, my client has, what is it, 10,800 in terms of monthly expenses.
Right.
If you divided that in half, that's 5,400. I mean, if you're looking at equalizing the parties' expenses, and in fact, I'm looking at Camille's financial declaration.
Sure.
Hers is what, 9774. Certainly, some of those expenses are going to be related to Derek, but I think you could look at it that way. You could divide them in half, but we're left with her claim that that's what it is. And listen, my client, he's mainly concerned about these kids, Your Honor. He makes a good income. He don't want to overpay his support. I mean, he understands that Camille's going to have some time to get on her feet. to get trained and get a career. But that goes to the custody provisions also, Your Honor. She needs his help. This is not a case for a long-term alimony award. She can't sit and wait to start training and educating herself. And so a 50-50 timeshare will help her as well as help the kids. It is the solution here. Does the court have any questions?
I don't at the moment. I'll give each of you approximately 2 minutes to give any rebuttal you'd like, and then I'll probably take a short recess. Mr. Johnson.
I do understand what I did with regard to the spousal support. What I was saying is spousal support would be the difference between what we get on a joint custody basis and then what's left over. So
Right.
it's the difference between Mr. and I had just overlooked that. So Mr. Peterson's surplusage is $6,593. So if you subtract child support in any amount from that, then what you're going to be left with is the expenses that Camille will have for being in the marital home and all the other personal expenses for herself and the children. I think this is actually a very elegant solution when you look at it, because we know Mr. Peterson can afford it, and we know he can afford it easily, because even if we don't scrutinize every single one of his personal expenses, which is both impossible and not very productive in my estimation, he can pay $6,593 per month on a temporary basis. And I'll state for the record right now that if for some reason any party, either one, can show that that's an incorrect amount and too much, then they can come back to court and ask for that change. I also think that because we're asking for a gradual implementation of this, we have a situation where mom is a stay-at-home mom and has been the entire duration of the children's existence, that we cannot simply jump into 50-50. And that's if we didn't have a special needs child like Silas. I do not want to prevent Mr. Peterson from having the ability to prove that he can make this work. But because we have Silas to consider, we should gradually implement it. And you'll notice I'm not asking it to take 2 years' time. We're talking about section 3335 for a month, 35.1 for a month, maybe a month and a half, or then get to the point where school is dismissed for the summer. And then Mr. Peterson will have more time under the Ackerman schedule. That's 10 overnights every 2 weeks compared to mom's 4. And then under Ackerman, it's 9 overnights with mom and 5 with dad during the school year, when dad, who is the one with the job, and mom, who has either no job or is less than full-time employed, can work. It seems to me Ackerman's schedule makes all the sense in the world in this particular situation. So in that regard, that's my 2 cents worth. And the only thing I would add is that it's not unusual for a person in Mr. Peterson's position to claim that he's far more involved than he really is. If he is as involved, then this gradual ramp up should pose no problem for him at all. If he's not as involved as he claims he is, this ramp up will reveal that. I just think it's a very equitable and very prudent thing to do. Any questions from the court?
No, I don't. Thank you. Mr. Hanks, I did have a quick question. In the pleadings, it talked about your client having a base salary, then a bonus. Is that a bonus that's paid, quarterly or monthly, or is there any kind of information on when it's paid?
I think quarterly, Your Honor, currently.
Okay.
But it just depends.
Right.
Point I want to make here, Your Honor, and I think it's an important point, is that when counsel addresses, let's give Mr. Peterson some parent time, see if it works, see how it does, and then we can ramp it up. Your Honor, what about Ms. Peterson here? We have a history of emotional concerns. They are not make-believe. They aren't exaggerated. We've got the text messages. We've got a doctor's or a therapist's letter that claims she has a diagnosis for anxiety and adjustment issues. We have this set of text messages, not just early on, but these go right up to the current time, where she is basically saying, I can't parent these kids, or she's saying they aren't being adequately cared for. You need to be involved with them. Your Honor, the question is, can she do what she's proposing? And there is real concern about her ability to care for these children properly. And that can't be minimized.
Now, let me ask you this. Couldn't those also be proof that he wasn't helping out as much and that she felt like she was doing everything?
Well,
Couldn't one read it like that as well?
well, we indicated, Your Honor, one of those text messages came when he was quarantined. He couldn't come back home,
Okay.
and she so that was for what, I think a week or some period. That short amount of time, she couldn't handle it. The other times are when he's working. You know, when he's working his 8 to 5 job, she had a difficult time. And so this has been a consistent problem during this marriage that Ms. Peterson has been absolutely stressed and overwhelmed with caring for these children. And I think probably some aspect of this is we're dealing with a handicapped child. That's a challenging thing. It's going to take both of these parents working together to parent Silas. That's what is needed here, and there is no need for ramp up. This Silas needs to see his dad. He needs to see him often. That will provide Silas with the best emotional and mental health to have the love and care of both of these parties. Any other questions, Your Honor?
No, I think that's good. Thank you. I'm going
Thank
to take a short recess. I want to go through the notes I've been taking and my prior notes, and I'll be back in just a moment. Thank you both.
Thank
Appreciate
you.
the argument.
All right, Robin, let's go back on the record. All right, thank you. Should we get Mr. Hanks, Mr. Hanks, Mr. Johnson, you there still? There we go. All right, thank you, counsel. I appreciate the arguments that have been made and the brevity. It was all listed out pretty well in the pleadings. I did allow for additional briefing on this. I felt like I don't routinely do that, but I felt like the issues were important enough, especially with the children involved in their issues. The court's going to make the following order. It is a temporary order. Along with this, I'll order the parties, if they haven't already, to attend mediation within the next 90 days. Actually, strike that, 120 days. I'm going to make the following order, and I do this thinking about, what's in the best interest of the child, what will meet the needs of the two children, and then secondarily with the parents. In this particular case, there has been a modification of positions by the respondent from just requesting solely primary physical custody to a modification to move in towards a 50-50. There is somewhat of a little concern that the court has as to how well the child that has some issues, autistic issues, will do with changing up the parent time and the overnights and where the child's sleeping on a frequent basis. I'm not sure if once or twice, is a good indicator, but I do want to make sure that things are going to go well. I mean, clearly dad should be involved, and clearly mom, like most moms, probably needs a break a little bit. There's nothing wrong with that. What I'm going to do is I'm going to award both parties joint legal custody on a major decision for health, education, religion. They should be working together to try to come up with solutions. At this time, I don't feel that there's anything in particular that there needs to be a final say. I'm going to reserve that, but allow the parties to try to work these things out and to work how to take care of their kids. If not, if there's an issue, the parties can try to mediate it, use their attorneys to help. If not, they can bring a major issue to the court if we're not able to get this resolved in a timely fashion. For physical custody, I'm going to award kind of a hybrid approach. I do think I want to see how I would rather there be more of a work into more time for the child at dad's house and more of that than immediately going there and then whether there's problems or not. I'd rather there be encouragement by mom to the child saying, hey, this is how it's going to be, and we're going to build it up. It's going to be more, and everyone's on board, as opposed to the kid having some issues out of the gate and then everyone's fighting as to what it should be down the road, if that makes sense. And so what I'm going to do is, beginning this week, I'm going to order that mom have a primary physical custody of the children for this weekend and the weekend of the 19th, through that up until and through March 26th, or up to March 26th, will essentially be under the 35 parameters, where they'll be every other weekend. But I am going to include that there should be 2 weekday evenings with the children with dad during that time. If I'm assuming that should go well, and then as on the weekend make sure I'm counting this right. Yeah, so the weekend, so that'll go not to the 26th, but actually through to April 1st. So April 2nd will be when the 35.1 timeframe would begin. And with that, there should also be an additional 1 weekday evening that the children could be with dad. And then beginning on the first Monday after the child's out of school, that would begin just a straight 50-50 time period. The advisory guidelines will be the default parenting plan until the parties come up with one on their own, since we have to have one. There are various restraining orders that are requested by respondent, paragraph 16 through 21 of the original motion. All of those are mutual restraints on the parties. They're all pretty standard. I don't really see any I haven't heard that any parties are really violating those at the moment. They should continue that. Then as it relates to the incomes of the parties and child support, I'm looking at petitioner, at least at the moment, with an average monthly income of $23,210. For respondent, she said she worked anywhere from 5 to 10 hours a week at $10 an hour. I think it's appropriate to hold her to 10 hours a week at $10 an hour. That gives her a monthly income of $433 a month. Child care for the 2 children, if they were in childcare as opposed to the current situation where she's working, the children go there, would clearly be substantial and would likely be more than what she'd be earning at $10 an hour after deductions. And so the court, at least on a temporary basis, is going to impute her at the 433. Child support on those 2 amounts, depending on the parent time situation, is modified. And so I'm not going to state that amount at the moment. I did look at the parties' incomes. I did not do a strict review like I normally do, where I cut a lot of things out because we do have excess income here. So what I did in my analysis is I looked at his income at $23,210. I felt it appropriate to impute a 28% tax rate on him instead of the 20, I think it was like 24 that he had. That's $6,499. When I subtract that from the 23, I get a net of $16,711. And let me, I guess bottom line is when I go down, I don't want to go through all the math, but essentially when I go down through it, he essentially, even after paying child support and all of those bills, there's still excess. When I hold her at the 433, her needs of the 5828, she still has a need. I'm looking at the total on that, and if I need to, I can go into all the calculations. But essentially, the sum total of what should be paid is the between child support and alimony should be the 5828. And I can go through all that if you'd like me to. It'll just take about another 15 minutes. But essentially, she has the need. He has the ability to pay when you account for child support and those needs. That matches up fairly well. I will also state, though, that there are various debts and obligations and bills that they both have on both sides of their ledger. They should be paying those as they've listed as part of their costs. The one thing that's not listed, however, that I didn't find on either party was healthcare costs and healthcare insurance premiums. Statutorily, I'm just going to order that the statutory provisions be covered, that both parties share that cost at this moment, and any non-covered expenses as well. If there's work-related daycare or childcare expenses, those should be statutorily shared. As it relates to personal property, parties can arrange a time. Well, I'm going to award the home on a temporary basis to mom. Dad, petitioners not to go to the home without their express written permission of mom. Kids cannot provide that permission. In addition, the parties do need to arrange a time for him to come and get his personal property that's solely his, that he uses, his work items. The issue of tools, as the parties can agree, he can take those. If there's a disagreement as to some of the tools, then that's going to be reserved. I'm not sure what all tools he needs if he's living at his parents' home at the moment. But if the parties can agree, great. If not, then they're reserved. They stay there in the home until parties can go to mediation or trial. The vehicles as the parties are using currently, and there's the costs that are associated with that. So he lists that he's making the automobile payments. She's listing that she's not. I'm presuming that he's making whatever payments are outstanding, and that's to continue. She's in the home. She's listed the mortgage payment as part of her budget, so she's going to pay that from the money that he provides her. If the parties have any separate debt in their own names, they're to pay their own separate debt. I know I'm feeling I'm missing something, but some of my notes I can't read. Am I missing anything on your side, Mr. Johnson?
Not that I can see. I mean, and I presume that the court, in doing its calculations, if it takes 5,828 and subtracts 2,704 for the mortgage, that leaves $3,124 per month to cover all the rest of Camille's costs.
Right,
Okay.
right. Which matches with what her budget was, at least for right now. And then, like I said, this is a temporary order. It's not, it doesn't bind anybody it doesn't bind anybody more than what this order binds them until there's a new one. But it's not prejudicial. Just because I've ordered something on a temporary basis doesn't mean that Judge Edwards won't, at the final trial, make some changes. This is just to try to help the parties move forward, to get some orders, get some parent time, and get some things moving. So, Mr. Hanks, have I missed anything on your end?
Well, I don't think so. The question I have goes to the parent time, Your Honor.
Okay,
So when, starting right now, we're Thursday,
right.
we've got a weekend. I assume he gets weekends during this, before we go to 35.1.
Right, yeah, I was assuming he'd have the weekend starting tomorrow. And
Okay.
then 2 weeks later that weekend, but
Okay.
then in the interim, there's still those 2 weekday evenings as well.
So he would get 2 weekday evenings during the 35 parent time. When we go up to 35.1, would he have 2 overnight midweeks?
Well,
And
he'd
weekend?
have 35.1 plus an additional weekday evening.
Weekday evening, okay, not overnight,
Right.
but weekday, okay. And then, okay, yeah, that
And
helps,
then,
Your Honor.
and then the other thing is when it gets to the time after when school ends and they start their 50-50,
Right,
I'm not stating whether it should be week on, week off. I don't know if that would be helpful with these children. It may need, I mean, I think there's going to need to be some massaging by the parties and counsel, because it may be that it needs to be 2 days and 2 days and then I'm not
Okay.
ordering anything because I don't know how well the children are going to do. And I'm more
Okay.
concerned about that than anything else. And so it may be where, some parties every Tuesday, and Monday, every Thursday,
Sure.
Friday, and then, but in this case, it may be where that the needs are such that instead of having essentially a 2-5 situation, it needs to be a true 2-2-3. But then the going back and forth may be too much, or maybe what the child needs so that there's enough contact with each parent, in a week basis. If that makes any sense, maybe I'm just talking more than I need to, but
Okay.
I'm leaving the 50-50 open up for the parties to try to work out what will work for this child.
Very good, Your Honor. That's all I
The
have.
only question on the, so for the 33-35 period of time in March, that's 2 weekday evenings, but not overnights. And then when it gets to 35.1, it becomes 2 weekday overnights, correct?
Well, you can all work it out how you want to, because there's so many overnights under the 35.1, right?
Right. I'm
So-
asking about under 35 for the month of March, you had 2
Right.
weekday evenings. Is that 2 3-hour periods, or are those 2 overnights as
No,
well?
that would be two weekday evenings, not an overnight.
Right. I just wanted to make sure of that.
Right,
that
right,
I'm
right.
undercounting.
Yeah.
Well, let me clarify, Your Honor. I think my understanding, when we go up to 35.1, we then have 1 midweek overnight and 1 midweek evening, not
Right.
overnight.
Yes,
Okay.
yes, that's
Yeah.
right. That's right. All right. Sorry to make it overly complicated for everyone.
No,
But
no,
I want to make sure that the needs of these children are met, and I appreciate that we're going to try something, and I'm hoping it works. I think there needs to be some encouragement from both sides that, hey, things are going to be okay. I want to make sure the parties know that if the kids ask any questions, and they may or they may not, they're not super old. The appropriate response is, hey, everything's going to be okay. We're working it out. And that's all kids need to hear is, hey, it's going to be worked out. Everything's going to be okay. So, Mr. Johnson, if you'll prepare the order, please get a copy over to Mr. Hanks for his review, and I'll wish everyone good luck moving forward. Thank you both,
I will
gentlemen.
do that.
thank you very much, Your
All right.
Honor.
Thank you. All right. I'm going to step out and take just a short recess, and then we will call the Welch matter. Thank you.